it's one or two more, and you do not know exactly.
Well, no, I know it was definitely one or two more.
But you don't know the exact amount, and you don't know their name.
Indeed.
It's a compounded question. We're on the record. No objection was raised out of the compound question, but proper procedure should have been objection, compounded question. You asked more than one question at a time, confusing the witness to answer and thus misconstruing the answer provided. So the record is going to strike the previous answer completely and allow you to either rephrase the question or move on. We're now back on record. You may continue.
That is all I have for right now, Judge. I just wanted to pretty much knock out the main stuff, which I did. I have no further cross-examination questions.
All right, very well. Officer Gosling, you may get up. And now you will have the equal opportunity to cross-examine anyone else here.
Okay, Your Honor.
Would you like to call anyone to the stand as a witness?
Mrs. Southern Sugar, if I must, sir.
Southern Sugar, approach the bench and raise your right hand. Plaintiff. Please raise your right hand.
How do you do that?
Okay. Point. All right. Southern Sugar, you do solemnly swear or affirm under the penalty of perjury that all statements and testimonies you're about to give this court are all the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You may be seated. You may begin examination.
So, Mrs. Sugar, can you hear me?
Yes.
Okay, so I would like to start off by asking you, you claim that I have stripped you of your rights and made you feel as you were not one of equal. Do you have any proof to even, like, back up that statement?
No. This is examination for questioning.
Okay, Your Honor, I apologize.
That's all right.
Okay, well, Mrs. Sugar, you claim that I've done all these things to you that aren't right, and, you know, you got an attorney involved with all of this, but from your behalf, we've heard nothing. You barely spoke, you've said nothing in the case file, and I just want to question, what are you trying to go off with all of this?
That's not a direct question. Rephrase.
Okay. Is it true that you claim that your rights were not read to you?
I plead the fifth.
You cannot plead the fifth.
I don't remember my rights being read to me, no.
Okay, Mrs. Sugar, and is it true that you're claiming that we did not give you the opportunity to request a lawyer?
Can you repeat that question?
I said, is it also true that you implied that me and the 3 other responding officers on duty did not give you the right to request a lawyer?
No, you all did say I could, you mentioned something about a lawyer, but, that was after I was arrested and booked and everything. I did also mention it's my first day in city and I had no idea what was going on, so I felt like I was taking advantage
Witness,
there.
witness. You only answer questions. You don't have to. You don't have
Yes,
to
Your Honor.
provide additional anything.
Yes, Your Honor.
Thank you.
So you're You're saying that your rights may have been read to you, no? Is what you
Objection, Your
just
Honor.
said.
What's the objection?
Improper lay opinion.
Come again?
Improper lay opinion. He's not asking her directly. He's making an interpretation.
Okay.
Yes, let's stay on track.
Okay, well, Mrs. Sugar, is it true that at the time of your arrest, you were in possession of 30 plus bricks of heroin?
Actually, that's false. It was not heroin.
So, Mrs. Sugar, if it wasn't heroin, then what was it?
I don't know. You guys were the ones that took it off of me and still have it in your possession, correct?
Oh,
Correct, ma'am.
It could have either been methamphetamine.
So, what was
or-
it?
Called to be heroin. Objection.
what's the basis?
Relevance. We're getting off track.
That
No, this is directly relevant.
Your Honor, let the record show that it was cocaine, please.
Let the record reflect it was cocaine. Is there any evidence that would justify that it was that which is claimed? Right. Any further questioning?
Objection, Your Honor.
Yes.
Authenticity to him trying to claim it was cocaine.
Sustained.
Your Honor, if I might add, it was stated in the arrest report that suspect was caught with 30 plus bricks of cocaine.
Yes, the court has acknowledged the report. The report is a narrative. It forms part of evidence, but the report is validated based on what? Evidence that can be reproduced. So, yes, factually we know that you or someone took that, and that was in the possession of somebody.
So,
Fingerprints, DNA evidence that would sustain that item being in the possession directly of the plaintiff could be admitted. Court is yet, however, to receive any of that.
Objection, Your Honor.
To what?
Wait, disregard.
Any further questioning?
Mrs. Sugar, would you agree that aside from your statement, there is absolutely no proof before this court showing of officer misconduct?
Did you understand the question?
No, I didn't.
Rephrase.
Okay. Mrs. Sugar, would you agree that aside from the statement that you gave Mr. Mazur back here, are you following so far, ma'am?
Objection, Your Honor. Speculation.
How is that speculation if it's some...
It's a guided question. He's trying to lead her to answer the question the way he intends her to want to.
No, if she answered a question previously while providing testimony or a claim that you made, is the claim, excuse me, the claim that, go ahead and ask the question again.
How about this, Mrs. Sugar? To put it in easy, practical terms, would you agree that there was absolutely no evidence here that shows any officer did anything wrong?
There's no proof, but that doesn't mean it didn't happen. There's no body cam from either side.
Well, that would mean that this entire court is all hearsay. So you are now openly admitting that there is no proof on either party, which means that everything here going on today in this courtroom is all hearsay.
Was that a question?
Yes, Your Honor, it was.
How do you answer? If
They
you
failed to follow SOP. Burden of proof is on them. Isn't their job to have body cam? It's my first day in city. I don't Like,
Circumstantial.
That is very circumstantial, Mrs. Sugar.
Is there any further questions?
Okay, Mrs. Sugar, my next question to you is at which point did our officers, as in me, Mr. Jones, and Mr. Luca, fail to provide you breaking of SOP? At what part did we fail and break SOPs?
Are you an expert in standard operating procedures?
Me, Your Honor.
No, the witness.
you falsely arrested me because I ran over someone. Because you claimed I ran over someone. Mind you, I was on a bike, by the way.
Yes, you were.
Oh, well, that's very important to mention.
You know
I
what
wasn't even in
vehicle-
a
so you
like
know
a
what
vehicle.
you were on when you hit someone?
I know what vehicle I was riding that day when you all arrested me. Yes. I would hope I would remember that at least.
So, Mrs. Sugar, do you recall why us three officers were called to your location to begin with?
Yes, you said there was a car robbery, and I wasn't even in a car. I had my own bike. You all said we were free to leave, so I went to leave the scene. I bumped someone. I said I'm sorry, and then I looked behind me, and I had 8 cops chasing me.
So, Mrs. Sugar, you
Objection,
are.
hearsay.
Mrs.
Oh,
Sugar,
who's
you
claiming hearsay?
Vega on what she's saying. She has no evidence of this. This is all hearsay. What she's saying.
Well, neither do
Objection,
you.
Your Honor.
Your Honor, I
Silence
would
in the
like to
courtroom.
add that she has just openly admitted that she bumped somebody on her way off the scene the officers were called to.
Yes, and I stopped and explained to you that it was a headache.
Far more than a bump. No, you didn't.
Okay.
There will be no more words from the defendants or the plaintiffs unless there's an objection statement. Please keep your words to yourself. This is between the judge, Ryan, and the defendant.
Okay. Do you have any additional lines of questioning?
Your Honor, I think that's all I have to say.
You sure? No further questions.
Okay. Well, you know what, Your Honor, if I must, I have one more thing I'd like to say.
Oh, no one say you must. I'm just ensuring that your line of questioning is concluded. If
Yeah,
not,
sure,
you
Your
can
Honor,
proceed.
I'd like to ask one more.
Go ahead.
So, Mrs. Sugar, you are now claiming that you did indeed bump someone when leaving the scene, correct?
I wasn't fully sure that it was someone because that someone was getting in and out of their car very quickly, and it looked like a headache, and I thought I hit their door. I yelled, "I'm so sorry," and then I went down the beach. So yes, I bumped something. Yes.
You bumped something. Okay.
Yes, and I stopped.
Well, without there being any proof of that, what you're saying now is all just hearsay, ma'am.
No,
Yours is hearsay as well, honey.
she is answering your direct question. You
You
cannot
asked me a question, I answered it.
you cannot claim hearsay when you're obtaining testimony.
Okay, Your Honor, I apologize.
Any more questions?
At this point in time, I would like to ask you also why, when officers chased you down the beach for bumping into something, you at first failed to stop and kept running from the 3 pursuing officers.
There you go.
I have really bad hearing, and I did stop and actually walk to you guys. I walked. I did not run.
And Miss Sugar, when we stopped you for questioning, were you or were you not being really aggressive towards the 3 officers on scene?
That's not true. I'm not an aggressive person. I was told to say sorry, and I did. I apologized to you directly.
Okay.
Mrs. Sugar, can you hear me, Mrs. Sugar?
Yes.
Okay, did you or did you not tell the two officers escorting you back to the police station that you were cheated on and upset?
Objection, relevance, Your Honor.
What's that got to do with this?
Sustained. Keep it relevant to case matter.
I don't think in-head business has to do with in-city business.
Keep it case matter.
Okay, Your Honor, I apologize.
Bring that up. Thank you.
Okay, Your Honor, at this point in time, I believe I am done with my questions.
All right, witness, you may step down to your bench.
Okay, thank you, Your Honor.
Yep. All right. There. Questioning is concluded. And now I ask the plaintiff this question. For your so-claimed or alleged violations of your rights, or whatever other claim is being brought or sought after, what does the plaintiff seek in form of restitution, in the form of compensation, in the form of whatever means the court would like to hear it? Mazur. I can't hear you if you're speaking, and we need to conclude with this matter. Can you hear me?
Mr. Sugar, can you hear the judge?
Yes. Sorry.
Mazur? Jello Mazur.
Yes, Your Honor.
What is your client seeking as a concluding matter for this case? Restitution, remuneration, what?
We are seeking monetary compensation and charges against the officers for alleged misconduct.
This is a civil case, is it not?
No, Your Honor, it's a criminal case.
Okay. So you're seeking restitution in what amount?
$200,000 plus fine and time served.
No, the maximum is 200,000.
It should be $200,000 plus the fines on top, Your Honor, if I'm not mistaken.
And who has approved that?
My previous lawsuit with Mr. Cinnamoni. Is from my understanding, since we revised the SOPs, if I'm correct.
Okay. So what is that final amount?
That would be $225,000, Your Honor.
225,000. Okay. Closing statements begin now. Plaintiff.
Your Honor, we ask that the court side with us and the citizens, as this is a clear violation of policies, law, and ethics by the police department. They failed to do their duty and job by having body cams. This solely rests on Officer Gosling to have the body cam footage. He was subpoenaed on a reasonable time within the time frame. He only had fragmented footage. He failed to do his job. He's making all these allegations that he's saying that he didn't do the misconduct. It's my client. She allegedly ran him over. Yeah, I'd never seen the body cam footage, which they're supposed to have. We subpoenaed them within a reasonable time. He failed to produce all the required footage. The burden of proof is on him. We're making valid claims, Your Honor. I don't see anything that we're claiming to be unreasonable. And they keep saying hearsay, this and that. Well, the facts are they didn't do their job. They don't have the body cam, which is written by the commissioner and the head of the police department. It is a law that they must have their body cam footage for 48 hours. He did not have all that footage. So our claims are reasonable. They failed to do their job, and at the end of the day, whatever we say is factual until proven otherwise, and nobody can say anything else.
Do you rest?
I rest my case.
Thank you. All right. Law enforcement also now has the opportunity to provide a closing statement to summarize everything. Do you want to provide a closing statement?
Yes, Your Honor.
Please do so.
Ladies and gentlemen of the courthouse, throughout my service, I have dedicated myself to one mission, and it's to protect and serve the great community of Neon with integrity. I've committed myself to this force to make sure I could do so. Every decision I've made and every action I've taken has been guided by a genuine desire to make this city safe and stronger. It is deeply disappointing to me to see individuals in positions of trust, such as members of the council, betraying such trust by bringing poison into our streets. While they choose to profit from spreading drugs and destruction, I choose to dedicate my life to removing that toxicity and giving back to the people of this city who deserve the better. My record stands as proof of my loyalty to the badge and to the citizens that I serve in this great city. I've always stood for justice and fairness and the rule of law, and no matter what challenges come my way, I will continue to uphold that oath that I made to the force when I joined. Not for recognition, but because it's the right thing to do. I am and always will be an officer committed to serving this community with honesty and dedication and unwavering integrity. That is all I have to say, Your Honor.
Thank you. All right. The court is going to enter a brief recess and shall return with deliberation. 5 minutes at most. Thank you.
Jello, you're not allowed to be here.
I'm not allowed to be here?
No.
Okay.
Do you
Go
want to
on.
do this here, or do you want to do this in command?
Let me.
Well, they deleted
There,
the
I'm on whisper mode.
broadcast.
After hearing everything that has transpired, I believe that
Cops that weren't even there.
there were more than one officer
It's just
involved
he
in
was
this
there, so I
incident,
trust my buddy.
and while sure, for one of them it may be true that the subpoena for evidence didn't reach them in due time, it happened. I'm inclined to believe that. But what about all other people involved,
Oh my God, I'm so sorry.
including Officer Gosling?
Fly on my neck.
I mean,
I believe Officer Gosling tried to submit his body
She didn't
cam,
punch me.
Smash
but it
that
was
horse
got
fly. It was a horse
corrupted,
fly.
which is beyond
sure,
his power.
Hold on. I'm gonna
right.
fix something
The only
real
things
quick.
I
I'm
have
gonna do that.
issues is on the record, Jello Mazer did threaten the officers. He failed to provide multiple subpoenas for the body cams requested.
Right.
The defendant, or the plaintiff, I'm sorry, the plaintiff was in fact read her rights and advised of a lawyer, which he claims she was not.
Mhm.
And she was also caught with a large amount of illegal drugs.
So,
The case
sure.
that I have against PD, obviously one, Ryan Gosling was unable to provide body cam.
Mhm.
The officers on scene did give her an opportunity to apologize and be set free.
Right.
Which, if she was taken into custody, I believe that there was some kind of interaction from her that justified the forgiveness to go ahead and
I don't know if I'm allowed to
do the arrest.
ask. There, I'll just type it to you. Yeah.
The plaintiff is asking for two things. And I find that it's not possible to have your cake and to eat it too, simply because there's no ill intent. There is no evidence of malice
Agreed.
on their end. If there was, that would make it a lot easier. But It's circumstantial. And although it is circumstantial, it has not been proven that it's repetitive. It has not been proven that it was targeted. I don't believe it was targeted. And it's okay. 200,000 plus fines and dues that already have been paid. 25,000. But then on top of that, criminal charges against the officer? No. You can't have both, unfortunately. Not in this case. There's no malice. So there won't be any criminal charges. That's at least what I believe. And as to the 225,000, well, the 25,000 are justified in returning the dues. I'm not saying she's innocent. What I'm saying is that without evidence, you cannot sustain any actions. At the end of the day, it is that which justifies your actions, that you're able to reproduce. If you're unable to reproduce, well, I understand it's circumstantial and it does happen, but unfortunately, there are repercussions to that. So,
Speaking on the plaintiff, correct?
no, I'm speaking on no body cam. I find that if maybe perhaps the body cam was not obtained or obtainable from one party, sure. Maybe even two parties, sure. But there were more than two parties present. It becomes too much of a coincidence that everybody's footage is unobtainable. That is too much of a coincidence. I don't think, because of lack of malice, there won't be any criminal charges, as so the plaintiff seeks.
Oh, I'm sorry, Judge. I don't mean to interrupt you right here.
Mhm.
As I'm reviewing the case, I do see that Ryan Gosling did, in fact, submit parts of the body cam. Those
Parts.
may have been fragmented.
Right.
Um, I believe that the corrupted file is justifiable. However, Jello Mazer did fail to admit to submit individual subpoenas for each body cam from the officers, which
Right.
clearly stated you must do so.
Right.
Also, I believe Jello Mazer may have been fishing this case because
Oh
the
shit!
initial
Her fucking voice box
request was
fucked
for
up. Hey,
expungement,
what you
not for a
watching about in the
lawsuit,
courtroom?
and Jello Mazer had
So
uh,
that shit. I
directed
am.
Miss Sugar into
Oh
filing a
shit.
lawsuit, which is fishing, sadly.
That requires another element. I mean, it has reached the bench. Uh,
Because again, sorry not to step in here, but it's because at the time there was no oversight in what was going on.
Oversight as it pertains to what?
As in, no one stepped in to say that this was phishing. When I was approached about this and
Mhm.
recognized the case,
Mhm.
I was unaware that
We'll talk about that at the PD.
Miss Sugar was only seeking an expungement and was
She's the
coerced
loudest
into
and the most
filing a
nosy.
lawsuit.
Coercing. How was she coerced?
So upon initial contact with Jello
Please
Mazer,
make it quietly.
Sugar Sky was only seeking an expungement from her record, in
Right.
which Jello
You don't have to
Mazer
scream. I'm okay with you talking, but like, don't scream.
talked
You know what I'm
to
saying?
Miss Sugar about filing a suit if she believes her rights were violated.
Right. What's wrong with that?
Well, and if an expungement is made and the plaintiff was already processed, then the case she'd already accepted charges for that case. If she had requested a lawyer and the lawyer was present during that scene, during that arrest, then there would have been all motions to file a lawsuit at that time. Unfortunately,
Yeah,
Sugar had
my ears
taken
really appreciate that.
the arrests on her record without a lawyer present due to her own
Perfectly
decisions,
fine. That's way better.
which means it has to be an appeal, not a lawsuit, which
But
is stated in our SOPs.
but you do understand the key element here, which is whether she had decided to pursue it in a manner consistent with an attorney
I'm speaking squirrel.
at jail cell or not.
I'm learning a new language.
She did not have proper legal counsel to help her determine
Squirrel language.
the.
Her own decision.
You can choose no lawyer upon arrest. Her limitation should not be constrained by at what point a contact with legal counsel was made, but rather that she is informed. Simply because she denied legal counsel during an arrest does not imply that that's a permanent choice. So even if there is some sort of a construed decision here arising from a lawyer's agenda or not, this is a narrative that
It was purple, dude.
needs further elaborating on. I don't see how one could conclude that a potential client seeking expungement can't change their mind later after receiving some sort of legal review. That's what attorneys are for.
Yes.
Now, I do bear in mind the level of involvement and personal agenda involved, but no one provided any objection or any illustration to this other than yourself. Meaning, impartiality. As a presiding judge, impartiality is at most single-handedly the most important part. To be moved by compelling evidence, regardless of who presents it, and making a determination based on that. I don't know if that makes sense.
It does. I'm just, stating my reasons, you state yours, and we'll go from there.
I have a solution after hearing this case. And according to what the plaintiff is requesting, it's asking for criminal charges to be pressed upon the officers. I'm not moving forward with that. And restitution in the amount of $225,000. I'm not granting that either. But I do find that there is a level of negligence, whether it be intentional or accidental.
I can agree.
I think that the only evidence I have of damages sustained would be the 25,000. And obviously, actual reproducible evidence. Yes, there's evidence that she was charged that. But what about the other 200,000? Well, I haven't received any evidence of damages that can be proven or sustained that would amount to 200,000. But the claim of her running over officers, to their defense, there's no evidence that this was all circumstantial. wrong place, wrong time. The fragmented scenes shows that at least he wanted to comply with the subpoena. I take that into account. Officer negligence, it's not negligence, it's circumstances. So I'm not going to award 200,000. I'm going to award the 25, and on top of that, I'm going to award 50. That amounts to 50 plus 25,
75.
75. So 75,000 is the maximum restitution that they'll receive.
Your Honor, may I make a counteroffer?
Sure,
This will save a lot of time.
sure.
What if we do 50,000 and the plaintiff's record will be expunged?
And that's fine too.
We can agree to this?
There's no agreeing. It's issuing of a sentencing, and that's that.
No, I'm saying we can agree that this is a fair compensation for the plaintiff to 50,000 and the expungement of her record.
That sounds reasonable to me.
Okay.
Deliberation.
You said what, Your Honor?
Ready for deliberation. All right. The court has examined and evaluated all evidence submitted. The court has at length analyzed everyone's involvement and everyone's intention. The following rationale is going to be offered as to how a conclusion was reached, and with fairness being at the epitome of everything that the court does. Rest assured that the following rationale for decision in this case was reached in a very impartial manner and only keeping true to evidence. The plaintiff in this matter claims to being wrongfully arrested, serving a prison term and fined, to which she initially, legally, only requested an expungement for. That expungement, or that intention to seek expungement, quickly turned into a lawsuit. One must take into account that's very easy for one who does not know the law to seek guidance from someone who does, and then determining thereof that they're entitled to something more than just that. It is true that although evidence has been submitted to the court in the form of brief encounters rather than one ongoing encounter, the court will take into account that there was a willful, active participation on law enforcement's desire to comply with the order. Furthermore, the court did see that at times people can get defensive. I understand that. And in the heat of the moment, you become very passionate for what you believe is just and fair. The court does believe that this arrest, although could have been supported by probable cause. The court has ruled that this arrest was not within the required elements in order to support a lawful arrest. The plaintiff, however, seeks much. The plaintiff seeks $225,000 and criminal charges pressed against all those officers involved. Plaintiffs can have any numerous demands as they may feel and think that is fair to request of the court. The court, however, is not a puppet. The court has to take many things into account. We are neither for or against you. We are here to ensure that at the end of the day, no one is above the law. And that is the rule of law, that no one is above it. Sentencing is as follows. The burden of proof will always rest upon whoever the accuser is. And although law enforcement was the initial accuser, the tide turned to the plaintiff to prove that all claims are justified. And through those requests and claims made, they proved to the court that there was a level of involvement from law enforcement that, although not negligent and very easily could have been accidental, nonetheless did happen. Police qualified immunity will be retained in this case, and therefore no criminal charges will arise from this encounter. However, the police department is liable for remuneration in the form of restitution to the plaintiff. Initially, $225,000. The court does not find that amount to have been justified through any means. So the court will not grant $225,000, but rather, to the very last dime you are to return to her any money you took arising from this encounter. And from $225,000, the court will expunge the record of the plaintiff free of charge and further grant her $50,000 to be paid immediately to her or her attorney of record. And this is the final judgment of the court. The court rules in favor of the plaintiff in the amount of $50,000. This case is hereby closed. Court is adjourned. Thank you.
Judge, don't forget the record expungement.
Alright, Mr. Sugar. Let's step outside.
The record expungement was already mentioned.
Oh, okay, I didn't hear you. I'm sorry. Are you able to delete cases from the NPT?
I believe so.
Okay, so we need to get that changed for lawyers to do expungements because they don't have the ability to.
They do.
Jello was telling me he didn't. He couldn't.
That's not true.
Okay. good to know.
Lawyers have always had that ability. We just made it to where it required some sort of a hearing in order to keep track of the cases that are expunged.
How do I go about getting her money?
You'll contact Vividon for the billing fee.
Yeah, he has access to the funds. Okay, thank you.
And don't forget, hey,
Mazur. Mazur.
don't forget under new rulings of our DOJ standards, you will be paid a 75K out of DOJ for representing the case.
Okay, awesome.
And I will grab that for you promptly.
Okay, yeah, I'm just gonna go get her stuff and then JRAR stuff too. So.
Okay.
Thank you. Thank you, guys. That was fun. Damn, this took 2 hours. Holy shit.
Well, that's because everyone wanted to talk over each other, and right there was a whole bunch of people.
It's not gonna
If
So I'm confused though. They didn't fail to follow PDSOP, so why aren't they being like charged or like held accountable?
there is lack of malice,
But I think like they only submitted portions of it though. That just looks weird. I mean, I don't really care. It's done, but I'm about to go get some coffee, so I just need to get my money, get her money, and then I gotta go to P get JR shit. I'm out.
really, the reason why it becomes more expensive is because people don't understand the process.
Okay, perfect.
If everyone would just remain silent and let the judge guide the proceedings, it would be a lot faster.
Yeah, I ain't gonna lie to you. It's definitely harder in person, just because like you gotta like know off the top of your head. Otherwise, there's gonna be like long pauses.
Yeah, that's another one.
You guys can speak among yourself. I need to go to PD and talk about DOJ DSOP changes, so they are aware of every situation.
Okay.
Yeah,
We're good then. Thank you.
This was amazing. Good job, guys.
All right.
Thank you.
Oh, Jose.
Yes.
As our new SOPs as well, if you request, if this is something you want to do just for the rollie itself, that's completely fine.
Mhm.
For every case that you represent, you are awarded 75,000 as well.
Okay.
So
where's this money coming from? Because DOJ don't make shit.
Let's just say government will be funding
Right.
portions of DOJ.
Yay!
However, once the funding runs out, that's when y'all need to take it upon yourselves to make sure that you're using the F7 menu properly to have a cash flow for DOJ. So, expungement cost, a percentage of that will go into the DOJ and will be used to fund your cases that you represent.
Yeah, those are easy. Yeah.
Okay.
Okay, thank you.
Jose, while I'm still here, do you want to take that restitution?
Sure. Why not?
Why not, right? Get
Yes.
a new car or a helicopter.
No, I don't need any of that.
Maybe get a new gun so we stop getting.
I have. You know.
Get a...
Personal
I
protection.
need to get a rifle.
No.
You need to get one of these guys. Come on.
Yeah.
Oh my
what the
goodness.
Fuck? Is that 50 rounds?
Oh, my bad. Oh.
Alright, I'm gonna head to PD. Have a word with their high command.
That was brutal. I'm not gonna lie to you.
Look. What about this one? This one's nice.
Oh, yeah, the combat AR. Wait, hold on. Have you seen this?
No.
Thank you for participating. I think we're good here, gentlemen.
Thank you.
I'm gonna head to PD to grab his shit. Jose, are you staying on?
Well, I don't. Is there any? Whoa!
No.
Look at that.
Yeah. I need to buy a rifle. I have 3-inch case. I wonder what kind of gun I can get.
Any?
Grab like a skinned SMG.
I don't give a fuck about skins. I just need an SMG or a rifle. I don't care about skins.
You can definitely get a rifle.
Yeah.
Okay. Well, if there's no further cases, I fly out. I just come in for that.
Thank you.
All right. Have a good one.
Right, thanks for your time, Jose.
No problem. Thank you. Well, let me deposit this. Ah!
He was definitely helping PD.
Yeah. I'll show you where